Rarely can there have been a more topical moment for a seminar. Felicitously, judgment in this claim was handed down just 4 hours ago, and the Home Office has already taken its first steps towards complying with the judgment by amending the instructions to its caseworker so as to broaden the range of people who are now entitled to the lifting of a no recourse public funds condition on their leave to remain, or to it not being imposed, so as to ensure that people who face in the future an imminent prospect of not being able to meet their essential living needs or of having adequate housing are not subject to the condition any longer. The text of the judgment is on the Landmark Chambers website, but please continue to tune in because this seminar aims to give you the full picture. To that end, we'll be hearing first from Caroline Hatton, or Kaz. Kaz co-founded the Unity Project in 2017 and has coordinated the project since. She has supervised hundreds of change of conditions applications and worked closely with Dayton Pierce Glynn and Landmark Chambers, gathering evidence from this work to support the litigation. I'm a huge fan of hers and the project she coordinates. It's real human rights work in one of those small NGOs run mainly by volunteers, offers a vital lifeline to a large cohort of people on whom our government imposes destitution. Next, I shall be speaking about the case, explaining some of the strategy, but mainly the nature of the scheme and the legal argument. I'm a barrister practicing at Landmark Chambers, mostly in claims against the government, public law, environment, human rights. Then we'll hear from Fiona Borden. She's a journalist and campaigner and has been coordinating the wider campaign and communications work on this NRPF litigation. She is co-founder of Impact Law for Social Justice, which advises on building campaigns around strategic litigation, and head of communications at the Legal Education Foundation, communications consultant to We Belong, Young Migrants Standing Up. And she also co-founded Legal Aid Lawyer of the Year Awards. And then we'll hear from Adam Hunt. He was the solicitor involved at the centre of this claim. He's a partner at Dayton Pierce Glynn, based in the Bristol office. He's worked for many years on cases involving the rights of migrants to access basic state services, in particular social security and healthcare. Since the No Recourse Public Funds policy was introduced in 2012, he and his colleagues have represented dozens of people affected by the policy, including now in the only two successful test cases, this being the second that we're talking about today. He'll talk about some of the strategy in this litigation, recognising that legal action alone can't achieve meaningful change. And so working with the Unity Project and Impact to produce both the research and the campaigning work around litigation and pursuing a multi-pronged case. He'll be telling us about that wider work and the strategy involved. Without further ado, I'm going to pass over now to Kaz Hatton of the Unity Project. Kaz, please follow on.
Thank you, Alex. And yeah, thank you to Landmark Chambers for organising and for hosting this webinar. Like Alex said, we're trying to pitch this to quite a broad range of people, so lawyers and non-lawyers, people from the government and people from NGOs. And also I know that there are a few people who are directly affected by no recourse to public funds who are listening. What we're trying to do here and in the work we do is represent you if you have no recourse to public funds. And if anyone has any further questions, especially if you're directly affected by this, then please do get in touch with us after the webinar and we can talk to you directly about your situations. So I don't know whether you'll be glad or disappointed to know that I'm not a lawyer. As Alex said, my role has been in setting up the Unity Project, and since then working with our supervising lawyer Rahath and with a huge team of volunteers. I actually got a slide just to, I'm sure they won't appreciate me sharing this photo necessarily, but I've got a slide here just to show a few of the faces behind the Unity Project. So together we've made hundreds of applications for recourse to public funds. But quite early on, when we started doing this, we suddenly realised that three main things. Firstly, that basically in what we were doing, we were kind of being an under-resourced, completely unfunded government department administering the government's procedures, and that we were going to carry on doing this indefinitely unless we tried to address the policy on a national level. And it wasn't only that we felt like we weren't changing things on a bigger level, we also realized that we might actually be making things worse by kind of plastering over the cracks in something that just needed to be completely rebuilt. And so that's why we, from the very beginning, built a relationship, firstly with Adam and then later with Alex and Fiona and with lots of other organisations, to try and address the policy on a more systemic level. So I've got 5 or 10 minutes. So I'm just going to really broadly summarise what the issues that we've seen in the last 3 years are, that have led to this litigation, and also just to try and humanise them, these issues, before we get into all of the legal detail, which will be the focus of the rest of the webinar. And I think one of the main things that I want to emphasise and I want to kind of set the scene with is that these problems that we're going to talk about existed before the Unity Project existed. They also existed before the pandemic kicked in. The pandemic has made things much, much worse, but it's definitely not the only cause of the problem. And these problems still continue to exist despite all of the work we've done and despite the government's response to the issues that we've highlighted. These problems still continue. And I say that not to be demoralizing or so that we kind of give up, but to say that this work is definitely ongoing and we need to acknowledge the things that have changed, but lots of things fundamentally haven't changed, and we all need to carry on doing the work that we're doing to make sure that things change in the future. So all of you are aware of No Recourse to Public Funds and what it is, and that's why you're here. But if you do want to read more, I just want to flag these 2 research reports. One is ours from last year, one is from the Children's Society, and that was published earlier this month, which gives a huge amount more detail and statistics and evidence about what the policy is, who it affects and how it affects people. I don't want to talk now too much in the abstract and give lots of statistics, but I do just want to share the story of, or the situation of somebody that we're currently helping with her application, because I think it is important that we start all of this and kind of always have in mind what this policy means on a human level. So I'll call her Ola, but this is somebody who we helped with an application last month, and she's still waiting for the outcome of her application. She has a 5-year-old British daughter. She's a care worker, so she's not earning a huge amount through her job, not earning much at all, and especially now because of the difficulties of childcare during the pandemic. So her income is less than the cost of rent for decent accommodation. So she's sharing a single room with her daughter, and they share an accommodation with 5 other adult male strangers who often have partners and other friends around, and there's a lot of drug use that happens in their shared accommodation. So they don't feel comfortable using the shared spaces and they're confined to a single room together. The accommodation is dilapidated, the school's visited and confirmed that several times. And also their doctor has confirmed that the conditions in the house are leading to her daughter developing some health conditions. Ola tried to make an application for recourse to public funds for the first time in the year that her daughter was born. That's why she first needed recourse to public funds. So that was in 2017. She's made this application twice. Both times the application's been refused on the basis that she can't provide enough evidence. I'll explain this slide in a second. She can't provide enough evidence of her situation. And so 5 years after she first needed recourse to public funds, she came to us. We've submitted the application and we're still waiting for the outcome. I think what strikes me, apart from all of this, about Ola's case is just that her daughter has only ever known the life that she's living now, and has grown up living in these kinds of conditions. And I just think it's important that we take a bit of time to think about what that means for her daughter and her future. So I think Ola's situation illustrates the two main problems, it's hard to say specifically what, there are lots of problems, but the two main problems with the policy as it stands, which this litigation is also trying to address. So the first problem that we've seen is the issue of discrimination. We often see people who, like Ola, are Black or minority ethnic, single mums of young children working in low-paid jobs, often as key workers. But I'll leave Adam and Alex to talk about what the legal implications of all of that are. The second thing that I want to just briefly talk about is the application procedure. Obviously, the application procedure hasn't given Ola what she needs, and this ruling has acknowledged that the application procedure doesn't prevent destitution. In our experience, it often prolongs destitution. And I just wanted to, before I hand over to Alex, just briefly, this slide is kind of more for reference. I'm not going to go through it all now. And I just wanted to apologise as well, because it's very unimaginative of me to have included an image of stacks of paper. I feel like I've never been to a legal presentation that hasn't included an image like that, but it does kind of sum up for us what our applications often feel like they look like. But I think it's important just to flag a couple of these things, because the application process has been tweaked in the past year in response to the work that we've been doing, but the problems with the application process are inherent, and they will only be solved once the policy goes completely. No amount of tweaking the application process is ever going to address these issues because they're just inherent. So just to talk about a couple of those bullet points there. One, the application form used to be very brief and vague. It was 5 pages, it asked 6 questions. We recently submitted an application that was 16 pages long and asked 200 questions. So we've gone from kind of one extreme to the other, but neither is fit for purpose. The other issue that I've mentioned there of proving a negative is something that obviously is illustrated in Ola's situation, but often the more destitute someone is, the more difficult their situation, the more difficult it is for them to evidence that, as Ola's case shows. So often people are homeless or staying with friends and don't have a formal tenancy, don't have formal eviction documents, and therefore can't prove their living situation. Something that we're seeing more and more actually during the pandemic is that people are in abusive relationships and can't therefore provide documents from or about their partner, which often prevents them from making the application. And sometimes the Home Office have sort of asked us, well, what should we do about that? There is no solution. Like, no amount of evidential flexibility is ever going to solve this problem. And so our answer to it is to get rid of the application process altogether and let the DWP assess people's eligibility for public funds. And just finally, another thing that's been sort of reviewed and tweaked in the past year is that the Home Office is now asking for further information rather than outright refusing an application, which we obviously welcome any genuine attempt to improve the application process, but in this case, we know that 1/4 of people that get this request don't respond to the request because they can't and they don't know how to provide the documents that they're being asked for. So these little tweaks aren't addressing the fundamental underlying problem. So I'll hand over to Alex. I just want to summarize, I guess, kind of four things briefly before I do. So firstly, I think it's important that we always humanize this issue and think about what it means to have no recourse to public funds and what it means to be growing up or to be bringing up children in this kind of poverty. Secondly, I want to just say that the background to all of this is the pandemic, and that has made things much worse, but it's definitely not the only cause, and these issues need to be looked at in the longer term. Thirdly, as lots of you will know, an immigration bill is going through Parliament at the moment, and that threatens to sort of extend no recourse to public funds to a much bigger cohort of people, which is obviously another worrying thing to think about in the context of all of this. And finally, just that the fundamental problems with the policy, which are about discrimination and the inaccessibility of the application process, are inherent to it, and they cannot be resolved by just tweaking the policy and the wording of the policy. So we really hope that that's not going to be the outcome of this litigation, and we'll continue to try and change things more fundamentally than that. So yeah, I'm going to hand over to Alex to do his job and what he's done so well for us in terms of kind of turning the things that we observe and talk about into something that's compelling and legal. So thank you for listening, and I'll hand over to Alex.
Thanks very much, Kaz. Since I introduced the matter, there's another 50 people I noticed. We're up to 300 now, so there's plenty of seats at the front for all the latecomers. I just want to begin by emphasising this. This is a significant judgment and with potentially significant practical effects in lifting thousands of people out of destitution. The Home Office has said that it will not be appealing, and this is at Divisional Court level, and so it won't be departed from for some time. It may take time for the significance of the judgment to bed in, and its implications may need to be enforced through further litigation. And hopefully it will be enforced now through the attention of bodies who should long ago have been calling the government to account over this scandalous component of the hostile environment. Bodies like the Equality and Human Rights Commission, the Children's Commission, and indeed Parliament have all been approached by campaigners and litigators over the years. Hopefully this will provide an occasion for those bodies to bring greater focus to bear on it. It may seem, when you get a chance to read it, a subtle judgment, but the case has drawn a real and marked line in the sand. Of course, I and those who worked on this case for a long time have grumbles and gripes that we didn't win every point and win every sub-issue, but the headline significance that we should be clear on, and I pay tribute to the graft of Kaz and Fiona and Adam and his team at Dayton Pierce Glynn for their dedication to the welfare of others on this, is that it does make a significant change. It's a magnificent judgment, written succinctly and elegantly. There are 3 points of legal significance that I'll explain shortly, albeit briefly in the time available. The first is that the duty in Article 3 of the European Convention on Human Rights not to subject people to inhuman and degrading treatment is a substantive obligation to achieve that outcome, to free people from that kind of treatment. But it also involves a procedural duty to avoid that state arising where the state causes such treatment. And so the state has to anticipate, obviate, avoid that state from arising. And that was the key component of the duty which played a part in this case. Second point is that the common law, so that's our judge-made law in the UK, it goes back to the time of the Poor Laws. I relied on a case from the early 19th century, has long protected against destitution. And this is important because the common law is embedded into our legal system. And so even if, as the Conservative governments repeatedly have promised, they repeal the Human Rights Act, our common law protections will subsist. Thirdly, the case is the latest in a developing line of jurisprudence as to the approach the courts take to challenges to systems, whether they be legislative schemes or policy frameworks, and it helps with the appropriate test to be applied when challenging such schemes. And I'll come back to that point shortly. So just to set up the context here, the claimant was typical of the cases that Kaz has just been describing. He was a British child, born in the UK when his father had indefinite leave to remain. His mother is a care worker working with mentally disabled people. She came to the United Kingdom from Ghana in 2009, and she has leave to remain here on a 10-year route to settlement. The defendant's policy and the challenge in this claim is, in summary, that when granting leave to remain, in this case to the foreign parent of a British child, the parent is required to make applications to renew their leave to remain every 30 months for the first 120 months, otherwise known as 10 years, after which the parent may apply for settlement, and a condition is then imposed upon the leave which deprives the parent of their right to recourse to public funds. And that's imposed in almost all cases unless the parent can either provide satisfactory evidence they are destitute or show that there are particularly compelling child welfare considerations that mean the condition should be lifted or not imposed. So the effect of that condition imposed on leave is to make the person on whom it is imposed ineligible for almost all benefits paid from public funds, including those intended to maintain the basic welfare of children. So the claimant's mother in this case, called Jay, has on various occasions since 2013 been given leave to remain, subject to a condition of no recourse to public funds. On one occasion, as a result of that condition, she and her young child became street homeless before being housed by a local authority. As a result of the disruptions that they suffered from these conditions, she's had to move house repeatedly, and the claimant, her young child, has had to move 5 times by the time he's 8 years old in terms of his school. He's moved 5 different schools. The no recourse public funds regime is comprised of the immigration rules and impose a presumption that the condition must be imposed. And those rules are then supplemented by instructions given to caseworkers as to how to operate the system of imposing or not imposing, or lifting or not lifting the NRPF, as I will call it now, the no recourse public funds condition on a person's grant of leave. So it's important to understand the hierarchy of the rules. Statute is at the top of the hierarchy. Statutes are passed by Parliament. They are the law, they are debated in Parliament, and so the courts defer to statutes because those democratically elected decide upon them. There are 2 statutory provisions relevant to this case. The first is Section 3 of the 1971 Immigration Act, and that provides the power to impose a condition on somebody's leave, but it's a mere power. It doesn't say it must be exercised. Indeed, the Secretary of State may decide never to use that power, and that would be a perfectly lawful use of it. The other statutory provision was Article 3, the European Convention on Human Rights, as transposed into UK law by Schedule 1 of the Human Rights Act 1998. And by Section 6 of the Human Rights Act 1998, a public body must not act incompatibly with that. And by Section 3 of the Human Rights Act 1998, legislation, including immigration rules, must be read and given effect so as not to infringe the substantive rights in the European Convention. And so, as I'm sure you know, Article 3 of the European Convention on Human Rights confers the right not to be subject to torture or to inhuman treatment or to degrading treatment. So we weren't dealing here with torture, but we were dealing with inhuman treatment and degrading treatment, which the jurisprudence confirms can consist of being subjected to forms of destitution, including homelessness, street homelessness, and the like, particularly for particularly vulnerable people like young children, such as the claimant in this case. So those are the statutory obligations that were relevant. Next down from that is subordinate legislation. There wasn't any at play in this case, but then we have the immigration rules. The immigration rules are laid before Parliament, but there's limited opportunity for Parliament to amend them. And they're said to be statements of the Secretary of State's policy. In this case, the relevant rule was GEN 1.11a of Appendix FM, and that was what provided that a condition of no recourse to public funds be imposed on someone's leave unless there's satisfactory evidence that the applicant is destitute. The next notch down from immigration rules are the instructions. They're policy documents, and they must not be inconsistent with the immigration rules. So the core submission was that the regime comprising the immigration rules and the policy documents were incompatible with Article 3 of the European Convention, as well as the cognate common law protection against destitution. That was the original submission. I'll come back to how it evolved in response to the moving position of the Secretary of State. The wider evidence in the claim showed that the impact of the regime was to impose poverty and destitution on children, and those impacts could be profound. People like the claimant, many children in his position who've suffered the extreme poverty that he has endured, will perhaps suffer disadvantage for their whole life as a result of the disruption to their education, the lack of proper accommodation, the anxiety, and indeed what is now acknowledged to be the inhumanity and degradation, to use the language of Article 3, that is caused by homelessness and poverty that the state imposes on people growing up under NRPF. Statistics disclosed by the Secretary of State during the litigation showed the claimant's case as typical. Over half of those who apply for conditions of NRPF to be removed are from Ghana and Nigeria. Many work in the care sector for the NHS or potentially as cleaners for the NHS. Many have British children. They are, in short, people whom the Cabinet will be clapping tonight while rendering them destitute. The successful ground of challenge in this claim, and in the end the only way that needed to be argued, was that this scheme was unlawful in two ways. It lacked the clarity necessary imposed by Article 3, and secondly, lacked the clarity required to avoid breaches of the common law of humanity. This claim was a culmination of a lot of work. Kaz, who's just spoken, has made hundreds of changes of condition applications. Any that were not successful were referred on to lawyers. My instructing solicitor, Adam Hunt, who's speaking next, explained in evidence that in the 18 months prior to filing this claim, which was started in July 2019, he had represented 20 families with a no recourse to public funds condition attached to their grant of leave to remain. Almost all had British national children with a mother en route to settlement. Almost all of those cases were successfully resolved with removal of the condition. None were unsuccessful, one or two simply not resolved yet. And so I'm grateful then to have been instructed on a handful of those. In one case, we got to the door of the court in March last year, March 2019, and the claim was settled after the judge, in fact, was ill on the day of the case. The claimant in that case, it was called the Crown, on behalf of, on the application of M and A against Secretary of State for the Home Department. The claimant received a payment of damages and an important agreement by the Secretary of State to conduct a review of the NRPF policy compliant with the public sector equality duty, because we had challenged the policy for failing to have been reviewed pursuant to that duty. However, having made that agreement to conduct the review, the Home Office dragged its feet. And so this claim, when it was brought in July, sought to enforce the agreement to conduct that review through various forms of pressure in this claim, adjourned hearings, and so on. The Home Office finally published an updated policy equality statement on 27th of April. I have to say, it didn't really feature heavily as in the end because we didn't need to, but it is a woefully inadequate document, fails to appreciate that the Home Office, what their own review and their own statistics showed, a glaring element of indirect racial discrimination in this policy. Not necessarily deliberate or direct discrimination, but it is there because this is a policy which is impoverishing and belittling a sector of society which is almost exclusively black and ethnic minority. It is a policy which is inherently hundreds of times more likely to impose destitution or poverty on black British children or minority ethnic group British children than their white counterparts. That was part of our case, but we didn't need to argue that because in fact, the arguments on the inhumanity and degradation caused by the policy to everyone it affects succeeded. The discriminatory effects of the policy remain a challenge that will, unless the policy is reformed, inevitably need to be brought. So the role of lawyers in bringing these kind of challenges is to force a rethink, open opportunities for that second look. So that settled proceeding last year in March was to force at least the Secretary of State to comply with the law, to look again. The Minister was forced to look again. We know that. We've seen disclosure that the policy statement and the review was taken to the Minister. His name is Chris Philp, MP. It's important he'd be named. He's an ambitious man. He chose not to review this policy. So 10 days later, we were in court and we had several grounds of claim, among them discrimination policy, public sector equality duty grounds, but all we needed was the Article 3 point. So I'll return to that. So it goes back to the Limbuela case that those of you long in the tooth will remember. In 2004, the House of Lords held in what's called asylum support that the Secretary of State was obliged to exercise power to grant benefits to comply with Article 3. I began with then a concession in this case the Secretary of State made, where they said on the back of the Limbuela case, they accepted that if the regime in question, the NRPF regime, requires an applicant to be destitute before the NRPF condition can be lifted, it will be ultra vires and incompatible with Article 3. But they said that wasn't the effect, and they had to read the regime as a whole and so on. So we then had some debates about how to read the regime. The court accepted on its face that it does require a person to be destitute, but I accepted that applying Section 3 of the Human Rights Act 1998, the scheme can be read down, that is, given effect in a way that it makes it compatible with the substantive rights in the Convention. So Section 3 imposes a powerful interpretive tool, allows courts to read laws almost to their maximum extent to ensure compatibility. And I said using that tool, it could be rendered compatible. However, nonetheless, we argued the scheme lacked transparency and clarity. This is a scheme where people are acting in person or through help of charity workers. Caseworkers themselves don't have legal skills. It's not good enough that the scheme be read in that way, subject to abstruse legal duties in the Human Rights Act, and the court agreed. So that's the first point. Next, the law of humanity. The court agreed with the argument made in reliance on a case going back to 1802. I'll ask you just to read it for the sake of time in the court's judgment, that the common law protects people against destitution and that the scheme did not respect those common law safeguards and they had to be excluded by express parliamentary confrontation with them. And if the Secretary of State wants to act contrary to the law of humanity, he can only do so with statutory authority, and that can only come from Parliament saying, yes, we want to overrule common law protection to prevent people from falling into destitution or starvation. They have to confront the inhumanity that they want to impose on people. Otherwise, the courts will presume Parliament would never have intended to do such a thing. And then coming to the last point, the court established that there are different legal tests applicable to challenges depending on whether the scheme is contained in legislation or policy. So in legislation, there had been a very recent decision in a case called JCWI, Joint Council for the Welfare of Immigrants. Where legislation is concerned, the test is, in order to establish that it is unlawful, the legislation must be incapable of being operated in a proportionate way in all or nearly all cases. That's what's said in the JCWI case. In the case of a policy scheme, the court looked at the judgment of the Supreme Court in the case of Beebe on English language tests. In such a case, the question is whether there is a significant number of cases in which the application of the guidance will lead to a breach of convention rights. Well, we were concerned with immigration rules, and they are, for Human Rights Act purposes, subordinate legislation, and so the court applied that test. They found that didn't apply, but they did find that combined with the guidance, the lack of clarity meant the scheme did not comply with the clarity and transparency obligations so as to ensure compatibility with Article 3 and the common law. I'm racing because I know want to get on to Adam's talk. So just a final word then is that this scheme remains a pernicious one, and one in which my view is subject to a number of other legal flaws, and it will be for politicians now and bureaucrats to look again at it in the light of this judgment. But if they don't reform, then they can expect further litigation to follow. I'll hand now to Adam Hunt, partner at Dayton Pearce Glynn, who was responsible for this litigation. Adam, if you could turn on your video.
Thanks, Alex. I'm hoping I'm unmuted now. By the way, before I start, I can see there are a few questions in the chat, which we will come to at the end, if that's okay. My multitasking isn't up to talking and chatting. I'm not of that generation, sadly. I'm going to start way back in late 2011, showing what generation I'm from, when at the Autumn Conservative Party conference, the then Home Secretary Theresa May misled the country by telling us that someone had relied on having a cat in order to avoid deportation on the basis of Article 8, the ECHR. Now, not only did that whopper not prevent her from becoming Prime Minister, it seems that telling porkies is now a prerequisite for that job, but that speech heralded the introduction of Appendix FM, a part of the immigration rules that was introduced in 2012 with the aim of severely curtailing Article 8 rights, to put it broadly. The main provisions that were debated at the time were the introduction of a minimum income requirement for people to come to the UK, the removal of in-country appeal rights, and an interpretive provision which set out the government's understanding of what Article 8 rights mean in deportation cases as a way of telling judges what to do in those cases. One change which was also introduced at the same time, but which was not debated at all, or much noticed really, was the introduction of a presumption that a condition that an applicant have no recourse to public funds be imposed on grants of leave to remain under what had hitherto been Article 8. Now, Article 8 leave had previously been called discretionary leave usually, and it was imposed with no restrictions, generally enabling you to access social security if you needed it. Appendix FM replaced that largely with routes to settlement for people who needed to be here for family reasons, curtailed the length of time that leave could be granted to chunks of 2.5 years. So people had to renew them every 2.5 years until they reached settlement, paying a fee each time. And each time there was a presumption in the policy that there'd be no recourse to public funds condition would be attached to the limited leave. So we started seeing cases in which this was affecting people in late 2012. And at that time, the policy was so crudely formulated that it was just a presumption in the policy that leave be granted subject to the NRPF condition, with no reconsideration process or exceptional circumstances clause or anything like that. Now, such a draconian condition was obviously unlawful, particularly when applied with no safeguards. So every case we saw was obviously challengeable, and anyone who came to us was advised that they could challenge it by judicial review. And we issued many applications for judicial review. So when I say we, I mean my firm, but I did the bulk of the cases, but some of my colleagues did some, as did other solicitors. We're by no means the only firm operating in this area. All the cases settled favourably for the claimant, basically because the decisions and the policy were obviously unlawful. Eventually, a couple of cases got through to trial. The first was the case of NS, in which the policy was challenged on 2 grounds. Firstly, They challenged the shorter timescale of leave, so the provision of limited leave for 2.5 years rather than indefinite leave, but also the NRPF element. Looking at the judgment, which doesn't always necessarily reflect the arguments that were made, it looks like the temporal restrictions on leave were more at the forefront, at least of the judge's mind, and that the no recourse to public funds issue was treated, at least by the judge, as more of an afterthought. And the claim was primarily brought on the basis that it infringed Article 8 rights and the Home Office's Section 55 duty to safeguard and promote the best interests of the child. To put it simply, it's a bit more complicated than that. That case was unsuccessful, but the next case that came through not long afterwards was the case of Faki, which was successful. It was brought on different grounds. Firstly, the policy that the policy was ultra vires, so outside the Home Office's legal powers, as it needed to form part of the immigration rules. If it was going to have that degree of strictness to it, not just being a policy document, and also that it breached equality legislation, the public sector equality duty, which hadn't been considered at all at that stage in the formulation of the policy. There was also a more individualised challenge to the assessment of destitution. That case was successful on all grounds. And in response, the Home Office was compelled to incorporate the NRPF policy into the immigration rules. It also brought in a change of conditions process in which people could apply to have the NRPF condition lifted. And they were also compelled to assess the equality impact of the policy. The policy equality statement that was carried out initially was published in 2015. It's quite hard to describe it politely because it was a quite breathtaking exercise in intellectual dishonesty. It was astonishingly poor. Each protective characteristic under the Equality Act was looked at in turn in a cursory manner, and at the end of each section, in relation to each protective characteristic, there was the same catch-all paragraph, same wording saying, I've shortened it, any discriminatory impact is addressed by the discretion to lift the condition in exceptional circumstances. Gibberish, really, legally speaking. Now, the public sector equality duty needs to be remembered as having come into being because of Stephen Lawrence. As everyone should know, Stephen Lawrence was murdered by racists, and the police bungled the investigation, largely as a result of institutional racism. That's not my view. That was the view of Sir William Macpherson, former Chief of Police, who conducted the inquiry into the errors, to put it neutrally, that had been made. And he made a series of startling recommendations designed to stop institutional racism in big institutions. His recommendations had cross-party support. There was a consensus that they should be implemented, and they gave rise to the equality duties, which were at that stage set out in different pieces of legislation, but are now incorporated into one public sector equality duty in the Equality Act 2010, Section 149. There's been a lot of litigation on that point over the years, but the main point of it has remained unchanged, and that is that it is deliberately designed as an anticipatory duty. That means you have to look in advance of what you're doing and decide to and see if there are any negative impacts on minorities, to put it simply, people with protected characteristics. And the other key element is that it's both positive and negative. So it's not just about addressing any negative impacts, it's about looking to see whether you can level up the playing field to avoid the inherent systemic inequality in policies or the way functions are carried out in the public sector. That positive anticipatory element of the duty seems to have completely passed most people by. And the point is, forgive me for labouring it, that it's designed to make people think about the impact of what they're doing on minorities and try to improve the situation for those minorities in order to gradually level up the playing field across the public services. If that is done in good faith and properly, what you should get in time are institutions and services which no longer inherently disadvantage particular groups. For example, if you look at the NHS, there are massive health inequalities. And as we are seeing in this pandemic, which is disproportionately impacting on people of Black and minority ethnic origin, that leads to serious injustice. So too here with the NRPF policy, because it disproportionately impacts, as any look at the statistics will show you, on people of a particular racial origin. Alex covered this, but I'm going to cover it again because it's really important. Basically, Black children and single mums are disproportionately impacted by this policy. And if you look at the policy with a genuinely open mind and actually want to comply with your legal obligations, that is the inescapable conclusion that you reach. And it drives you to the conclusion that something needs to be done to improve that and stop that happening. Sadly, that hasn't yet happened, despite a further policy equality statement having been produced. It seems to have been produced in order to defend the policy, but sadly. So at that point, after seeing the PES, the Policy Equality Statement of 2015, we realised that this needed to be a multi-pronged campaign. So with the Unity Project's help, we kept on challenging the policy as it applied to individual people and brought lots of cases, well over 20, all successfully, because the policy and the decisions made under it were obviously unlawful. And at the same time, we built up evidence of the impact of the policy. Each case became evidence in itself. Eventually, another case came to trial early last year, as Alex mentioned, and settled shortly before the trial on the basis that the Home Office would conduct a public sector equality duty compliant review of the policy. That was in March 2019, and after that, over the next few months, we, the Unity Project and others, wrote to the Home Office repeatedly asking for details of this review, but heard nothing. Further cases came forward, and eventually we issued the case of W. I'll spare you the litigation history because we're running out of time, but it's a pretty sorry tale. Suffice to say just a few things about it, because I can't resist. It should have been heard in December, but the Home Office managed to get it adjourned on the basis that there was an election coming and that the review would be completed just after the hearing had been listed to take place. The new deadline came and went, nothing. The hearing was then relisted for the end of March. But then the government sought a further adjournment on the basis that the review would be completed just after that hearing. Insert raised eyebrow. It was listed for the 24th of March, but on the 23rd of March, lockdown happened. So the hearing was adjourned again at that stage because the admin court was kind of trying to figure out what to do in lockdown. So we applied to have the policy suspended pending the outcome of the hearing, as at that stage it looked like hearings like that wouldn't be happening for many months. And in early April, there was a hearing of the application to suspend the policy, but a pragmatic way forward was found under which the full hearing would happen very quickly. So we didn't push the suspension application, and on 6th and 7th of May, the full hearing happened. As Alex has explained, we gave the judges the option of looking only at the Article 3 ground, and they took that option, leaving the discrimination provisions untouched, and they announced their decision the following day so that we didn't have to argue the remaining issues. The judgment was handed down earlier today. It's available on the Landmark Chambers website at the moment. It'll be up on our website as soon as we've resolved our technical glitches, whatever they are. I can't, beyond me to understand them. So it means the discrimination arguments haven't been resolved. So there may well be a further round of litigation on the point, unless the government looks at the policy properly and decides that it actually wants to do something about its discriminatory impact. Sadly, I'm not holding my breath on that front, but if campaigners, lawyers and legislators can hold the government to account, I might be proved wrong. If not, we'll have to go back to court. One more point, final point, sorry. This case isn't really a new development in human rights law, and what struck me when I read the judgment is that the court found that a case from 1802 tells us how to act humanely in 2020. So I'll just leave it with that thought, bringing it back to the infamous speech. Far from developing too far, far from human rights law having developed too far, as Theresa May wanted us to believe at that time, I think what it actually shows us is that our actions have regressed to Dickensian days. And that's a pretty damning conclusion. I'll leave it there.
Thanks very much, Adam. I think if all the speakers could come back on, then we've got a series of questions on the chat. Please send some more in if you've got them now.
We need Fiona, don't we?
Yeah, we're moving to Fiona next. Don't worry, Adam. Yep. I'm just collating them as we go through. So when we get the question section, if you could have a look on separately what I'm sending through to each of the speakers. Next up, we have Fiona, who's going to tell us about the campaigning work involved around this. I've already introduced her at the beginning. Very experienced campaigner, founder of the Legal Aid Lawyer of the Year Awards. Been involved with that recently. I shall hand over now to Fiona. Thank you.
Thank you, Alex. Yes, so as Alex mentioned, I'm a journalist by background, and I am co-founder of Impact, Law for Social Justice, which I set up along with Shauneen Lamb. Shauneen is a barrister and was one of the founders of Just for Kids Law, and she and I worked together there on a number of successful campaigns built around strategic litigation. These included litigating over young migrants' access to student loans, and also greater protections for arrested 17-year-olds. So those are both issues which could well attract negative press comment, which would be unhelpful for the cases and potentially damaging and distressing for those involved in them. But we found that with careful planning and preparation on our part, all the coverage was extremely supportive and positive. So when Adam contacted me over working with DPG and Unity Project, I was really keen to be involved. I know DPG well, I know the calibre of their work for a number of years, and I could really see the potential for having a comms campaign as part of like an additional string to the legal team's bow with this particular case. Actually, I should have my, I'm going to try and do a slide now. Can we have the next slide, Anna, if you're there? Hang on. Sorry, folks. Okay, here we go. Yes, so some of the lawyers in the audience may be wondering why you need comms when you've got this rather wonderful tool called the law. But for me, I was just trying to show a quote, but the slide doesn't seem to want to complete. Anna, can you do anything? Oh, thank you very much. Yes, so this is a quote from Michael Claimant, who's a Harvard law professor. And this book is about how, despite strong support among much of the population for equal marriage, every time the court rules in favour, there's a sort of massive outcry against it. And what he's saying here, and what I believe, is that if you have a legal victory in a vacuum, you may not have a legal victory for very long. It was fairly obvious that if you have a case involving migrants and benefits of any description, you are likely to provoke a fairly hostile response. At that point, a lot of people will just, the shutters will come down, they'll stop listening. And we needed to find a way to talk about this case without that happening, if we possibly could. So we wanted to find a way, the comms element was to try and explain why this policy, which at least in part had been introduced in the name of encouraging greater integration, was actually driving children, many of them British, to the absolute margins of our society. So it was doing the absolute opposite of what was stated to be its intention. So our audience for the campaign, for the for the comms element was not just the public and the media, but also politicians and policymakers. And from my experience of the work that I do, which is a group of young migrants, it's quite clear that the people making these decisions often have absolutely no idea what impact their policies are actually having, and that makes it very easy for them to defend them when they possibly shouldn't be defending them. Another reason for having a comms string to your bow, as we've been touching on earlier, is that often a win in court isn't the end of the matter. There's still going to be a tussle between the campaigners and the government over the detail of any new policy, and the comms campaign is about trying to create a public and political climate where it's harder for the government to take a hard line on things like that, so that they may actually have to produce a policy which does actually do what the campaigners are hoping to achieve. There are other benefits of media coverage. Unity Project had a spike in people contacting it for help when they saw the stories about the case and the outcome, that is obviously a positive thing in its own right, but that's all work that can then feed into any other potential legal action or any potential policy work. And it also, again, the reports of the success of the case generated interest from other potential funders who might be interested in supporting Unity Project. So, you know, you get side benefits of work as well from doing communications around a case like this. Now, Adam and Alex have given some sense of how complicated this area is and what a fiendishly complicated issue no recourse to public funds is. You have to expect a fairly low baseline level of knowledge with journalists. Even the good ones don't really have a strong grasp on these issues. So our challenge was to try and explain it to them so that they could explain it to readers in a way that was going to be helpful and supportive. And this is one example of what we came up with. Oh, here we go. I don't know if people can actually read that or not, but all of this is still on the DPG and the Unity Project websites. All the press releases and things are still there. Now, no doubt, if you can read it, some of the lawyers will be cringing and wanting to caveat every word in that press release. But for the comms side, we focused on the fact that the case was being brought in the name of an 8-year-old British boy being supported by his mum. One thing that was really interesting to me about this was we had lots of discussions with Adam and with Alex to some extent in the run-up to the case, but it was never mentioned that the case was being brought by an 8-year-old boy, and I only found that out by accident when I was looking on the DPG website for something, and it just shows you that to Adam with his lawyer brain, that was a legal technical device, but for me that was going to be the heart of the story, and in the press releases and in my conversations with journalists when I was trying to interest them in the story, you know, that was kind of what I focused on. We talked about the welfare safety net rather than NRPF, which nobody understands. We talked about how the decision would provide a lifeline to families. We talked about the boy's mum not being able to earn enough to keep him properly housed and fed. The research that Kaz mentioned that Unity had done was incredibly useful. There was a huge amount of detail in there, which although didn't actually feature particularly in the coverage that resulted from this case, was really helpful for me to be able to explain to journalists the severity of this policy and the impact that it was having. And although we couldn't name this little boy for obvious reasons, we could give enough detail about him and his situation to make him real to people. And Alex has already spoken about him having to move school 5 times, bearing in mind he's only 8, and having been street homeless at times with his mum. And as Kaz said, it was also really important to Unity Project to make it clear that this wasn't a crisis triggered by the pandemic, that the pandemic has simply made an absolutely desperate situation immeasurably worse, and that the problems would linger longer than the virus if nothing was done to address this. And so this is a little medley, if I can get it, of some of the coverage. We had coverage everywhere, ranging from the Metro to the FT, plus the Guardian and the Independent, the BBC, and the ITN also devoted considerable resources to covering it. And it was all very positive and covered the story in a way that sort of fitted in with the aims of what we were trying to do, which was to explain how absolutely brutal this policy is and how it's blighting so many lives. Obviously, I was careful to work in the main with supportive journalists, people who I knew would understand the story and take the time to report it fairly. And other than a few snarky comments on Twitter, it's all been positive, everything that I've seen anyway. So we really hope and believe that this gives us a good foundation to build on any future, whether they're legal challenges or policy work. And as Kaz has mentioned, the work and is definitely very much ongoing. So that's it from me.
Thank you very much, Fiona. We're going to start picking up the questions then. We've had quite a few, so if we can just get Kaz back in. I'm going to start with quite a lot of the questions have focused on Zambrano carers. I'm just going to pick up the difference here. Zambrano carers are a form of well, they enjoy a form of derivative right from EU law. So where the child in question is a European citizen, so they could be British or from another EU country, they enjoy a right to freedom of movement within the EU. And the decision in the Zambrano case said that in such circumstances where they need to be looked after by their parents can be removed because it would be an interference with the free movement rights. So there are a category of people called Zambrano carers who enjoy entitlement to remain in the UK solely by virtue of their child's EU rights. And those are called derivative rights. And in those cases, there's already been Supreme Court authority, a case called Crown on the application of HC against Secretary of State for Work and Pensions and others, in which the various statutory schemes that have been engaged in relation to Zambrano carers were examined for their discriminatory impacts. Zambrano carers are excluded from certain benefits under a separate form of statutory regulation. And so in this case, and in many cases, although she is a parent of a British child, she was not a Zambrano carer. She's here enjoying leave under the parent route, which is not granted as a result of her Zambrano rights. So that's the short answer. In essence, this judgment does not apply to Zambrano carers who are Zambrano carers, but be careful to ensure whether a person is indeed a Zambrano carer or whether that's being used as a shorthand. So I think that picks up those. There's quite a lot of other questions. Maybe I could bring in the others. Kaz, did you want to pick up some of the questions? Quite a lot about wider application of this in other situations.
I should preface anything I say with the fact that I'm not an immigration lawyer, so I can't necessarily give full answers to these questions. But one thing I did want to say, I saw a lot of questions relating to people who are on who have different kinds of leave to remain. At the moment, people are only eligible to apply for a change of conditions if they have limited leave on the 10-year route under Appendix FM. We know of people who are trying to look at that and look at whether that's challengeable given the pandemic. So if anybody knows of specific cases of people who have no recourse to public funds on a different immigration route, but need recourse to public funds and currently can't apply, then please get in touch with us and we can see if we can link you up with a lawyer who might be able to challenge that. Also, I don't know if there was anyone asking this specifically, but anybody whose leave to remain is pending, it's a really difficult situation because obviously often the Home Office takes months to make a decision on people's leave to remain, and we would normally advise that somebody waits for the decision on their leave to remain in order to be able to remove the restriction from that leave to remain. We're now making applications, and no other organisations who are making applications for people whose leave to remain is pending. So if you're in that situation or advising someone in that situation, then again, feel free to get in touch if you want advice or help with those applications. I don't know if there are any more specific questions.
Well, I think Adam, did you have a point you want to speak up, Adam? Adam, have you got any ideas? You want to add in any questions? There's one.
Sorry, you're very faint now.
There are quite a lot of questions about people, well, about the broader application of the judgment outside its strict terms. So, of course, any judgment only applies to the specific facts before it. But one of the situations people were asking about was people with no leave. So, obviously, if you have no leave, you don't have a condition on your leave imposing no recourse to public funds, nor do you have any obvious right to access public funds because you're not enjoying any leave to remain or any status of any description in the UK. So this has no specific application to those people in those situations. However, Adam's closing thought, the law of humanity, as it was called in the 1802 judgment, is that the state can't compel people into destitution. So that case we're talking about, the one that goes back to 1802, was all to do with laws against vagrancy. So people used to wander about in great poverty in the early 19th century, and parishes would try and send them back to where they'd come from. For the other their sort of parish of their origin to deal with them. Poor laws, they were called. And the court said, well, yes, that's what the statute says, but in the interim, you've got to feed them and look after them until you can return them. You can't wash your hands of them. So those basic principles that the case has drawn out as now reflected in Article 3. Of course, Article 3 of the European Convention always was intended to build on great common law principles like that from British law. It's brought those back to the fore and brought back how the state can't leave people in these states of destitution. It offends our common law and it offends human rights. So those basic principles, yes, they may well apply in other contexts. Adam, did you want to pick up any questions?
Yeah, there were just a couple of queries that I've seen. One question about whether this applies to people with no children, and sorry, we have focused on children in our talks because that was the claimant was a child, and that was what came out of the statistics. But in actual fact, the judgment applies to everybody, not just children or people with children, to answer that question simply. And more broadly, kind of echoing what Alex just said, that essentially the state has to act to prevent people reaching the state of destitution that constitutes inhuman and degrading treatment. So that isn't specific to even the NRPF policy, let alone to particular aspects of it. That principle applies across the board where people are left to get to that state before being able to secure some help. There was one other question I've just picked up on about local authorities. We did actually have evidence from the NRPF network, which is an organisation that that represents local authorities in England primarily, and disseminates good practice and legal updates and so on, but also helps lobby central government, because it's one of those things that, as the questioner pointed out, it's one of these policies that kind of shifts the responsibility onto local authorities to address, and so we did have evidence that pointed that out. In the end, it wasn't referred to in the judgment, but I think it probably played a part in the judge's thought processes, I suspect.
If you pick that up, Adam, I mean, there was certainly in my skeleton quite a lot about the impact on local authorities, because when the Immigration and Asylum Act 1999 was passed, the background to that, if you read the judgment, you'll see was a to and fro between the courts and the Home Office and Parliament, trying to work out what the parameters were for excluding migrants from benefits. And what happened was the court said you can't deny people so they're in a state of destitution. Parliament then passed some rules that got pretty close to achieving that. But the indirect consequence of it then was to just throw the whole obligation for saving people from destitution onto local authorities. And when they came to pass the 1999 Act, Parliament realised that that's what had happened as a result of excluding migrants from benefits. And they decided to bring it back to central government. And that's how Section 95, Section 4 asylum support emerged, was that central government should be funding support for asylum seekers, not local authorities. And that's very much the intention then behind the scheme. So that was part of the statutory background that we steered the courts towards, that central government should be funding, looking after people in these positions, not throwing it all through Section 17 onto local authorities. I'll just pick up one more point. Someone just asked, what's the threshold before Article 3 can be activated? So Article 3 protects against inhuman treatment or degrading treatment. And in Limbuela, that was said to include street homelessness, or perhaps short of that for someone very vulnerable. But what this case really clarifies is that you don't have to reach Article 3, because you don't have to reach inhuman or degrading treatment to activate the obligations under Article 3. Because Article 3 is an absolute right. It imposes what you might call negative obligations on the state not to put people into inhuman and degrading treatment. And that means they have to act well before you get to an inhuman or degrading state of affairs. You have to act to anticipate, to obviate that state of affairs. That's why people who are likely to become destitute are entitled to the NRPF condition being lifted if that's what's causing the likelihood of their destitution, or its lifting would alleviate that likelihood. So destitution is the threshold. Likely to become destitution is good enough. Destitution is defined in statute as not having adequate housing or not being able to meet essential living needs.
Can I just develop that slightly further? Just so in practical terms, what that means for advisors, and someone pointed this out earlier in the chat, pointed out that, or asked, in fact, do we still need to make representations and provide evidence to establish that the person would be destitute? Yes, exactly. And what in practical terms that means is that you go much earlier. As soon as there is any indication that that is what's going to happen in the future, you put in the application with the evidence that you have. So that might be a reduction in hours, it might be an increase in rent, it might be illness that means that you can't work for a bit, it might be maternity leave, all those sorts of reasons. As soon as that happens, or it might be your landlord serving a Section 21 notice or whatever, saying, look, I need you out, I want to sell the place. So before, what we were often seeing was the Home Office saying, no, you're not desperate enough, and refusing the application. That would be unlawful. That's what this judgment is very clearly established. So you get the application in quickly, and as soon as that is a prospect. And I would argue that the impact of the judgment extends to the Home Office having to process that application quickly enough to prevent destitution from occurring. So they can't sit on it for weeks, well, I'm sure they don't sit on it, they've probably got a stack to get through, but the point is they're going to have processes that get through them quicker, so that people aren't left waiting for too long. So those are the sort of practical impacts in answer to that question.
Can I just add to that yeah, I think a few people have sort of been asking this question about the practical impacts. Like I was saying, we haven't necessarily, I mean, we haven't there hasn't been enough time for us to see what these changes will mean practically. One thing to say is that we will continue to monitor how the application process is working and continue to challenge it in the way that we have done. But also, I think it's important to say that now is a time where we need to be working together in other ways, and not just through making applications and not just through litigation, but also through Parliament and campaign work to make sure that all of these things come together, and that this judgment, which is saying that this policy currently breaches human rights, as well as all of the other things that we know about it, to make sure that means something in practice. And that can't just be down to a small group of people to do that. I mean, all of us have got to kind of play a part in making sure that that happens and holding the government to account. And it's not an easy task, but definitely it's not over. Like, the NRPF still very much exists, and all of these problems still exist. Like, this ruling in and of itself isn't going to change everything, but it's a stepping stone to hopefully changing things.
Questions? Yeah, Adam, sorry, carry on.
There was a question about childcare, access to childcare. So this judgment doesn't directly impact on that, but there is some other litigation going on at the moment that's relevant to that. I believe that Matthew Gold are taking the lead on that. So I'm not quite sure the best way to get in touch with them about it, but you start with their website, and it's probably got, I think it's got an update on where they've got to with that. So yeah, the simple answer is that there is no direct impact. And similarly, on the judgment that was publicised today or yesterday on the fees, the fee waiver policy, again, it's not particularly, I mean, it's connected in practice because the people who are impacted by this policy are also impacted by the fee waiver policy, but in legal terms, I think the bases of the claims are quite different. Is the short.
I mean, it's quite interesting actually that they did both judgments come out within sequential days, because the fee waiver policy does have a destitution test in it, but actually has a much more robust one than the, it already builds in exactly what we were saying should be built into the immigration rules. So, I mean, it's interesting on that front that, one hand of the immigration directorate doesn't know what the other's doing, really. There was another question about child benefit. Do you want to answer that, Adam? Whether child benefit is excluded from the NRPF? Not really, because it's complicated. Maybe Kaz can.
I can't answer the question, but I do want to draw attention to it because it's something that we've been, I mean, Adam and us have discussed it for years. It used to be that there was an exception for parents of, with certain exceptions for parents of British children. Since Brexit, that's changed. Lots of people got letters to say their child benefit was going to stop, and often it was their only source of support. Then they got letters during the pandemic to say, oh, actually, no, we're not stopping it. Basically, nobody that I've talked to sort of really knows what's going on. I don't know if the DWP knows what's going on, but I just kind of want to do a shout out. I know there's a lot of lawyers here. If anybody can challenge this, it's a really good point, Faith, that British children are unable to claim child benefit because of their parents' immigration status. And obviously you want to challenge no recourse to public funds much more broadly than that, so that there's no restrictions for anybody. But it does seem like a point of challenge, and even the lack of clarity that the DWP gives very mixed messages about it. So
I think that's the key point there, the lack of clarity, because I mean, I've looked into the legislation on it. It's really complicated and quite difficult to navigate. I think there's a clear argument that people should be getting it. I know that CPAG now disagree with me. Great, they know better than me. Sorry, looking on the chat. But I think it's arguable either way, and it's unclear. And there is a challenge to be made there. The thing that's holding me back on that front, and I think should give other lawyers pause for thought, is that if you lose, your clients claim public funds, which might not be okay. because of the terms of their leave. So there's a potential risk there to a client, which makes it a very swallow hard kind of thing for them to advise them to do, which is why organisations like CPAG and so on are well placed to try and lobby on that front, do some policy work on that front, possibly litigate in their own name, or as public lawyers we could challenge the lack of clarity on it, but it's a bit harder for to crystallize that form of challenge. So that's why it's a massively complicated question, really good question to have asked, but I can't give you any clarity on it, I'm afraid.
Okay, I think we're just going to take the last question now, which is quite a good one to end on, actually, which is from Henk, I don't know how to say the name, I'm sorry, Henk Swade. What do you see happening in the next 2 to 3 years in relation to government's policy on migrants? Do you expect further litigation will be necessary to raise the various points you've raised in this meeting to deal with the various points? Well, the first part of that is a political question, and I don't think any of us are perhaps any better to answer that than anyone else. I mean, we can all make our judgments about what we think might happen at policy level with this government. We've seen the attitude they've taken today to fee waivers. So it's anyone's guess, but I wouldn't be too hopeful, absent being compelled by some groundswell of public opinion or by litigation, that the hostile environment will let up much. I do feel there's a slight change of direction perhaps, but not huge. As to litigation, certainly I think there's plenty more scope for litigation here. We had several grounds that we didn't pursue because we didn't need to win this case, but they still seem to me to be perfectly arguable. We've been granted permission in several cases, and we will certainly follow up if we need to, but we hope to give the Home Office a bit of an opportunity to review the policy as a result of this and see whether it wishes to pursue it and continue with it in its current form, or whether something more humane will emerge. There's certainly discrimination grounds that are latent. The government does need to conduct further public sector equality duty reviews, because what it did exposed the discriminatory impacts of its policy, but didn't confront them as required. It does need to look in detail at the immigration rules and how they're framed as a result of this judgment, whether they comply with Article 3 and the law of humanity and the common law. And it does need to really consider whether all of this should be entrusted to the Secretary of State for the Home Department, whose record is not good in this or in many respects, and whether in its place really Parliament should be scrutinising schemes of this scale in legislation, as indeed the rest of the welfare system is regulated. So I think with that, I'm very grateful to Kaz and to Fiona and to Adam for taking part. We are half an hour beyond now, 5:30, so really grateful for everyone sticking around for all the questions, but I think we should draw it to a close now. We will try to answer any questions sent in separately to us. Thank you all for attending, and good luck. Goodbye.